It is now 3:06, and on Thursday, February 19th, and we can now call the Planning Commission meeting for the town of Cave Creek to order. Um, since our last meeting, appointments to the commission were made by the town council. I believe congratulations to Charlie on his reappointment. Thank you for all your contributions. You're highly valued, and congratulations to Josh Wedge.
Thank you.
Commissioner Wedge has a strong desire to be actively involved in our community, and from my experience with him, he wants to help wherever he can. And we thank you for stepping forward.
Thank you.
It's actually, Mr. Chairman, Josh used to pick on me in high school.
Oh, come on now.
So it's really no different, this opportunity to be able to boss me around. So he's very comfortable in that.
Some things never end. All right. With that, I guess we can do the pledge. Pledge allegiance to the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. I guess the pledge takes you back to grade school too. I don't believe we have anybody here to speak to the planning commission. And I don't know if this was noticed for public. It was?
Yes. Yeah.
Okay. So if anybody wishes to speak to the planning commission this afternoon, please fill out a request to speak form available near the entrance. If you have any items you'd like to be considered, please give them to the clerk along with your request to speak form. The planning commission is the advising and recommending body to the town council on matters related to zoning, land use, the general plan, and the town core plan. Our recommendations to the town council on matters are just that. They are recommendations. Town council is responsible for making the final determination. Regardless of how you ever feel about a matter passing from the planning commission with a recommendation to the town council, in favor, opposed, or neutral, and you want your opinion considered, it's your responsibility to attend town council meetings and express yourself. I don't believe we have any unfinished business.
No, Mr. Chair, I would like to introduce Tracy Wilgus. She is our senior permit tech for the town. I have harangued her into sitting as clerk for this planning commission meeting and future planning commission meetings.
Awesome.
So
like Tracy.
Yeah, Tracy.
Is awesome.
When you envision government getting things done, Tracy is at the core of that with our permitting process and everything with the town. So she definitely makes the wheels of government go round. So we're extremely indebted to her volunteering and stepping up to do this for us.
Thank you. Is a familiar face? That's always nice.
Yes.
Before we get into any new business, while we're waiting for Commissioner Miller, perhaps you want to give a report or okay?
Sure. Yeah, I can. I was going to save that to the end, but we can move that to the beginning. As the chair and commissioner are aware, there was a joint work session held with the town council, I believe on November 12th of last year, where some different items were brought up as potential items that the planning commission may look at as far as ordinance revision, subdivision ordinance revisions, and things of that nature. Staff has spent some time looking at different things. As you're aware, with House Bill 2447 being adopted in the town, amending its ordinances that no longer require site plan review to come before the planning commission or council. That was really the bulk of the work that staff and the planning commission had previously. This gives us a good opportunity to look at our town code, our zoning ordinance, our subdivision ordinance, our technical design guidelines, and bring forward recommendations for amending certain sections. Our next meeting in March will essentially kind of outline all of those and get commission feedback on what they would like to see in upcoming revisions to those documents. So you'll be seeing a lot less of me necessarily and a lot more of our planner, Eric Baker, and senior planner, Stephen Perales. We're going to kind of split the workload between the three of us and each focus on a specific text. So Stephen Perales will be looking at the subdivision ordinance. Eric Baker will be working more closely with the zoning ordinance, and I'll be looking at the town code. So with that, just to give you an example, and one other project that we did identify was the town owns several properties that were essentially given to the town or the town purchased for open space. Those properties are still zoned as they were gifted. So in one case, it's zoned commercial. In another case, we've got some residential properties. So we'll be preparing minor general plan amendments to change the land use to open space and concurrent rezonings to bring forward to the Planning Commission and ultimately Town Council to essentially amend the zoning from a residential or commercial zone to an open space zoning category. It's kind of a neat project. It's something that Bambi said we needed to do 15 years ago, and we're just getting around to it now because we've got the time to do things and take our time and do it right.
So when those were deeded, were they deeded with deed restrictions?
They were not. They were not. So they were the town. The town just purchased a 20-acre parcel last year, or not purchased. The town took as a donation a 20-acre piece of land last year that zoned DR 190, for example. So we'll do a minor plan amendment, which we can do as a minor because the general plan allows us, if we're going down in density, to process it as a minor. So we'll be changing the land use from, I believe it's low density 4 is the nomenclature in the general plan to an open space, and then processing it.
Where's the?
We purchased with DFLT before I started with the town, property on Saguaro Hill adjacent to the library. There's two-acre parcels there. DFLT owns one, the town owns one.
Backside by Galloway?
Right along the ridge line. So if you
Okay.
go and look west or east out the library, it's all that hillside there.
Okay.
So there's that. There's several properties that are DFLT owned. And we'll be working with Desert Foothills Land Trust to talk about doing the same with them and cleaning up the zoning for those if they're interested.
Yeah.
So, but yeah, we've, the chapter 3 of the zoning ordinance, table 3.5, the allowable uses. We've talked about that for a few years, doing PUDs, PADs, accessory living quarters. There's a whole host of things that either the verbiage in the text of the ordinance needs some fine tuning, or we just need commission's direction on how they want to proceed and give it to council for a policy direction. So a lot of things to keep us busy, and we'll, like I said, start in March, give you guys a briefing and get your feedback on what you would like to see in different areas.
Yeah.
So that's the end of the meeting. Oh, yeah, I think now that everyone that is supposed to be here is here, I think we can move to the first item on the agenda, which is the nomination and selection of the chair and vice chair to serve this year.
Okay, so as far as chair and vice chair, I guess we'll start with chairman. Do we have any nominations for chairman?
I'd like to nominate the current chairman.
Do I have a second?
Second.
Any other nominations for chairman?
No.
Okay. I guess we can call a vote. Imagine
Just a
this
voice
one.
vote.
Want to do a voice vote? Yeah. Voice vote, all in favor?
Aye.
Aye. I was gonna pull it away.
That's why I said just a voice vote. Fine.
Okay, with that done, next up is vice chair. Do we have any nominations for vice chairman?
I nominate Clayton.
I'll second that. Any other nominations for vice chair? None. With that, we can call a vote. All in favor?
Aye.
Clayton Miller is appointed vice chairman. Congratulations.
Thank you.
I'll be
Congratulations.
absent from all future meetings. Okay. I think that was our only agenda item. So with that, I guess we can turn it over to Kristen Mackin.
Yes, so Mr. Chair, is customary, every year, it's typically done in January. This year, the calendar got away from us a little bit, so I apologize bringing this to you in February. But as is custom, we have a presentation of Town of Cave Creek Legal Counsel, Kristen Mackin, covering the role of the Planning Commission, open meeting law, and legislative updates which may impact the Town of Cave Creek. So I will turn it over to Kristen.
Hi there. I hope everyone is doing well. I can actually only see you in a tiny little box. So so if you're like trying to get my attention or something, you'll really have to like just speak up or like really wave your hand or something, because Luke is really big with the empty room there. And then you guys are really small and I don't know how to switch the screen. So we'll just proceed. Let me share my presentation if I can. Most of you have seen most of it before, so I'm not gonna belabor any points if you that we've gone over multiple times, but if it's always good to have the refresher. And if you want have any questions, of course, hypotheticals and just questions generally about what I'm going over, or if I went too fast, just rein me in, let me know. So first, okay, just a reminder, you all know this, but the commission is commissioners. Your job is to primarily advise the council on planning and zoning, policies, plans, and amendments. And as Luke noted, the scope of what you look at has now been significantly reduced. So you can really it sounds like, focusing on the policy and the planning, and then, text amendments to clean things up and update in the code. Of course, we're going to be cognizant, right, about the restrictions on rezonings and amendments that might constitute a new land use law and subject a property to a claim under the Private Property Rights Protection Act, but we can keep that in mind in the future as you move forward. That was legislation that you all are very familiar with now, that was adopted in 2025. Now your zoning ordinance has been amended. There were not very many amendments last session that needed action for you all, a lot that applied to much larger municipalities. One, interestingly, that would apply to you if your zoning ordinance did not already have the required language, which it does. So congratulations to you all for including that in the zoning ordinance in the first instance. So that's great, but other municipalities may have to amend their zoning ordinance if any of their regulations or related to sober living homes have zoning ordinance setbacks between sober living homes that does not include a procedure for modification based on the Fair Housing Act. And your zoning ordinance already has that, so that's great. No amendment will be needed to address that. There's some new I don't really, not applicable, I guess, to you all except for the commission, but it is at least relevant to the town. And there's a new housing requirement talking about pre-approved housing design plans. So that might be something that the town might be working, or the council might be working on in general, or the building department. But I didn't see anything else from 2025 that was particularly relevant. Luke, am I missing anything that you're aware of?
No, and correct me if I'm wrong, Kristen, but most of the legislation that is really hitting is targeting municipalities of greater size.
Yeah, much bigger.
It's kind of been over the last maybe 5 years or so. Just looking at municipalities of 30,000 population or greater, 40,000 population or greater. So we're kind of small potatoes in that regard, correct?
Yeah. Yeah. So a lot of that it's been active on that front, but not applicable to you. I mean, some of them are 150,000 or more, so population, so much bigger municipalities. There was almost, I guess, since I don't have anything interesting really to say about 2025 legislation, I saw there was almost going to be a bill this session on a new economic development zone, but that it looks like it's already been through a strike, everything, so that's not gonna be an issue right now. I saw some things I saw in 2026, the current legislation that's pending, that a little bit more on housing, some improvement amendments related to improvement districts, I think, to make them slightly easier. Right now, they're not very easy to form, and something about development fees. So we shall see if any of that comes to fruition and ultimately impacts the commission. So I'll let you know next year. Or Luke will let you know earlier, I guess, if we need to have an amendment to the zoning ordinance before. Okay, so then we'll just turn to some of the legal update, just to remind everyone about due process. And when you do hold your public hearings, the purpose of the public hearings is to provide adequate due process for your applicants, and that requires a fair trial and a fair tribunal. This is not really a trial, but basically notice and a hearing which provides a meaningful time and manner for the applicant to be heard. And so that's when you have requirements to hold a public hearing, such as on a rezoning, and one of your obligations when you're reviewing a rezoning is to take into consideration public input and testimony at that hearing. So you're fulfilling the role of providing due process at this stage.
I have a question.
Go ahead,
Yeah.
Mr.
The due process, does that extend not just to the applicant, but to the general public as well?
Well, yes, I mean, the statutes require, the due process really is for the applicant, but the statutes require for an open public hearing, that would, I mean, the purpose is to provide an opportunity for the public to speak as well. So there's lots of things that those hearings are providing, but you don't generally, I don't think I've ever seen a due process claim from a member of the public. That would come from an applicant, or maybe an adjacent property owner that claims they didn't have an obligation and a good opportunity to respond, but I can't off the top of my head think of any cases like that. But the public hearing part is important to your consideration of an application.
I was just wanting to point it out just because I would think as the planning commission needs to be concerned about a due process claim from a resident. If we were to, let's say, decide a matter before the hearing and the resident didn't have a chance to come and speak and talk.
Right. Well, and I would say that's an absolutely would be a problem, not providing due process, because that wouldn't be providing the hearing. If a decision was made before the hearing, then you haven't provided that meaningful time and place to be heard.
Well, I think that's happened before, no? Has that happened before? I'm
I'm
not talking
sure it
about Cave
has.
Creek, other jurisdictions.
I would say absolutely it's happened before,
Yeah.
which is why those laws are put in place.
Exactly. And also it's problematic under your open meeting law, which we'll get to. So, of course, just a reminder to avoid mingling with, generally the public or friends, applicants, objectors particularly before a hearing. Like, I mean, obviously you can mingle with whomever you want outside, but before or after a meeting in which there is a hearing, that's just kind of an appearance of impropriety that could be taken from that. Avoid discussing any case pending before you all with either other commissioners, even if it is less than a quorum, or council members. That preserves due process. Well, before the you as a commissioner hear the case. After the commission hears the case, it's a little bit different, but avoid discussing it before you hear the case with other commissioners or council members. Avoid offering opinions or advice to applicants or other council members, commissioners on any pending case or a case that you know is about to come before the commission. Never indicate how you intend to vote before or during a hearing. This goes to your point to ensure that we are providing, or the commission is providing, a fair and impartial hearing, and that all comments made during that hearing can be taken into account, and that there isn't, the commissioners aren't sitting up there with a predetermined view, because that could subject the commission to a due process complaint. And to also ensure that decisions are based on the zoning ordinance, legal requirements. You can, staff will be providing any technical compliance information that you need. And then, of course, you always can speak to Luke, planning director, for questions in advance so that you know what may apply to a hearing or an application, I mean. And to remember that you are acting in a quasi-judicial capacity in that, and so act like an impartial judge until it is time to vote, or discuss until it is time to discuss. So you avoid supporting or opposing, and have more impartial discussions. Be polite, attentive, and impartial. Not engage or argue with presenters or objectors, or interrogate. So I am sure you all are familiar with those, but I just wanted to, it's always a good idea to go over them again. There is a code of conduct applicable to commissioners. The planning commissioners shall treat people with respect, regardless of race, age, religion, gender, sexual orientation, or disability. Should not unlawfully discriminate against any person or group of persons. Planning commissioners are expected to fully participate in commission meetings while demonstrating respect and courtesy to others, practicing civility and decorum in discussions and debate, listening courteously and attentively, and engaging in effective communications. Planning commissioners shall not place themselves in situations where their honesty and integrity may be questioned, should not behave improperly, and should on all occasions avoid the appearance of such behavior. And planning commissioners shall deal with the employees and services of the town through the planning director only when acting in the role as commissioner, except for the purpose of inquiry, and should not give any direct orders or instructions to other town employees. And these are in your town code, if I'm not mistaken, adopted in 2021, I believe. So we'll move on to the open meeting law. I think you all were provided a copy of that as well. We'll move on to the open meeting law because that is critical to what you all do and what we're here in right now, an open meeting. It is the public policy of the state that meetings of all public bodies be conducted openly, and that notices and agendas for those meetings contain information reasonably necessary to inform the public of the matters to be discussed or decided. When in doubt, assume that a court will assume or favor open and public meetings. So always keep that in mind when questioning whether something is a meeting or a discussion should be had. The statute is 38-431 et set, and it applies to when you have a meeting is a gathering through either in person or technological devices like I am appearing via Zoom here, of a quorum of the members of the body at which they discuss, propose, or take legal action, including any deliberations by a quorum with respect to that action. And of course, quorum is for you all, a 7-member commission is 4. That's defined by town code. And even if you have some vacant seats, you will still have 4 members required for a quorum. But as long as you have a quorum under the open meeting law, you can open the meeting, and then you only need a majority of members present to take action. Splintering the quorum is the easiest way to get into kind of a pickle with the open meeting law. And that is separate or serial discussions with a majority of the members, a quorum of the members of the public body. And this does not have to be at the same time. And that's why it is particularly kind of, I guess, tricky and something of which to be aware of on a regular basis, because it can happen with, a discussion with one person, one other commissioner, and then, that commissioner goes and talks to another commissioner, but any mention of what the first commissioner said to the third commissioner, now you have 3 people that have discussed the issue, if it's an issue that's coming before the commission, and one more person added to that would end up with an open meeting law violation. It doesn't matter if it took place over the course of, a few days or a week, or longer, I guess.
And Kristen, if I can just interject real quick, just on
Yep.
this, I don't want to scare planning commissioners in just being siloed. We will generally publish agendas 2 weeks in advance, and I know there can be some questions related to the case material that they're getting to review ahead of the meeting. We want to encourage you to contact town staff individually with your questions. It's been a longstanding tradition that, if we get questions about a case, that are, technical fact, yes or no, do they need to provide this driveway egress or anything like that related to a plan or a case? We consolidate all of those and give the answers to the entire board ahead of time, so that, if there's little kind of onesie twosie questions that you may not want to bring up in public, or just to save kind of the time of answering just the low hanging fruit type questions. Like I said, reach out to staff, let us know your concerns, or if sometimes it's even good to let us know, hey, I didn't see this information contained in the packet. That gives us the opportunity to go down, track that information down, and disseminate it to the entire body. So yeah, I just want to, that last bullet point there, just make sure that doesn't mean, you don't want to play telephone. Oh, Chairman Breckner wanted me to pass along this message to you guys. That's not what we're talking about. If there's additional information, let us know. We'll get it to you guys ahead of time.
And that serves the purpose of making sure that you all are as prepared as you want to be for a good and positive discussion during your meeting. And it helps you continue with your business in that meeting, because if there are questions that can't be answered right off the top of a staff member's head who happens to be there, it might end up having to postpone the discussion or something. So that type helps move things along. There was a relatively recent Attorney General opinion addressing a school district's practice of holding, they call them 2x2x1 meetings between senior district staff, like superintendent, and members of the governing board in advance of the meeting. And the Attorney General found that that was a violation of the open meeting law. And there was a later, more recent clarification, within the past year, that opinion did not find that all 2x2x1 type meetings would be a violation of the open meeting law, but it seemed that the Attorney General's office was particularly persuaded by the fact that in those meetings, the board members, discussions were held with the board members. So it wasn't just asking a question so that they could have a discussion in the public, but part of it was having some of that discussion privately, even if the intention was to make the meetings more efficient. The Attorney General found that anything that was facilitating not holding the discussion part in public was, that was the open meeting law violation. So that's an interesting finding, finding there, and not, 100% clear, very fact dependent, but what Luke outlined below doesn't run into that same problem that was addressed in that decision. And then, of course, polling, just in case anybody doesn't know, would be if one person, including a staff member, goes around and asks individually which way a commissioner or board member might be inclined to vote, or getting their kind of temperature on an issue. That would be polling, and that would be not permitted. Okay, so I think I've already, this probably goes without saying, but discussing is that collective exchange of facts or opinions, and that's what must occur in public. Legal action is collectively making a decision or a commitment on any matter up for action. Propose, because you can't propose legal action to a quorum without being in a public meeting. And unlike discuss and legal action, which requires more than one person, propose could be a unilateral action. For instance, it could be, someone could put forward for consideration, discussion, or adoption an issue, while also proposing like the specific action, not just, I think we should consider looking at our subdivision code. It would be a more specific proposition. I think we should consider, ensuring that, we, reduce all the setbacks on, this type of zone. I have no idea. But that could be a unilateral action that, if you put that in an email where a quorum members of the commission were copied on that email, then you could run afoul of the open meeting law. So that's why it is best to never have any commissioners or other public members of the public body on an email, and communicate solely with Luke directly. And that's why emails you get from them will probably have everybody on the commission be CC'd, so that nobody can accidentally reply all and inadvertently run into a violation. Of course, you all don't have executive sessions very often, but it could come up. You're allowed to convene an executive session for certain types of specified exemptions. The only one really relevant for you all would probably be for legal advice. And so if that's the case, and you have to take the vote in public to, go in, it has to be properly agendized, then you can go into executive session. Everything that happens in executive session stays confidential, including the minutes. Of course, some easy ways to run afoul of the open meeting law that may not occur to you: passing notes amongst each other during or immediately before or after a meeting, whispering or talking to fellow commissioners during a meeting, privately using modern technology, being your phone. So say, a hearing is running late and you need to, text your wife or your kids, so you're going to be late, or, ask what's for dinner, that even though you're not doing anything related to the business of the body, it could appear that you were, in which case that could at least result in a complaint and some sort of investigation into that. A quorum of individuals, of commissioners, talking before the meeting starts or right after it ends. So make sure you're not hanging out in a group that looks like a quorum. And of course, failing to keep confidentiality of executive sessions, and failing to advise persons about the confidentiality requirement. Generally, that would be the job. If you go into one, that would be the job of the lawyer. But if you go into an legal advice, or the primary staff person that recommended the session. Any questions about the open meeting law? Consequences: each violation, civil penalty up to $500. Any person affected may file a suit in Superior Court. It could result in the invalidation of any legal action that was taken in violation of the open meeting law, requiring you to start over on that. Could have some potentially significant impacts to an applicant. Generally, no public money may be spent by the public body or officer as a result of the violation. So while the you'd be provided a defense of a claim, if there was a violation found, that would be your own obligation, a personal obligation, and in an extreme scenario, you could be removed from office. I've already addressed these best practices, I guess. Yep, avoid decisions based on personal opinions, not relevant or rationally related to the matter at hand. When you're during discussions and deliberations, if you use or mention some sort of arbitrary or irrelevant standard that isn't, part of the, the code, the general plan, within your guidance, the purview of the universe of what you all can consider when making a recommendation. If things outside of that are discussed, it could implicate a due process claim, and that would be more of what we call substantive due process, and that is when a decision is really arbitrary and capricious. And that's a much more kind of extreme scenario. It has to, generally the cases have said that the action has to have shocked the conscience. And that won't always happen, but it doesn't mean that it won't lead to the claim, even if it's, not rising to the level of shocking the conscience. So, and I've already reminded everyone, be cautious of reply all on emails. Then we have a couple of slides here just to briefly remind us to think about conflicts of interest on anything that comes before you all. They're not bad, they happen, but if you do have an actual conflict, you have to ensure that you have identified it, disclosed it, and disqualified yourself from considering, even participating in any way on the matter. So first, it's complicated definition, but any public conflict of interest is any public officer or employee who has or whose relative has, and relative is defined by by statute, a substantial interest, also a defined term, in any decision of a public agency, shall make known such interest in the official records of the agency and refrain from participating in any manner as an officer or employee in that decision. You cannot simply participate through a discussion of a matter and then abstain from the vote. You cannot participate in any way. And the zoning ordinance, and I guess I didn't check, Luke, I don't know if this has been amended, but Section 14 provides that if a member has been present for the entire presentation, the member may abstain from voting only if the member has a conflict of interest. Of course, we hope that member would have recused themselves from the entire matter before that gets to that point, but you can't simply go through a discussion and then choose not to vote unless you have a conflict of interest. So, and substantial is defined as anything that isn't a defined remote interest. And there are about a dozen or so types of remote interests defined in statute. And then that also requires that you have a conflict would require a direct or indirect pecuniary, monetary, or proprietary interest. So if you don't have that, then you can have a conflict. But if you don't have a remote interest, you don't qualify, your interest isn't qualified as a remote, and you receive some sort of direct or indirect pecuniary or proprietary interest, then you have to declare the conflict. And so it's a good idea to look through those regularly. because they are strangely worded. They haven't been updated in a long time, and they can be difficult to apply in practice. So if you do have a conflict, you declare it at the outset. You have to make a written disclosure that is kept on file. You refrain from participating in any manner, and then that conflict is recorded in the official records. Does anybody have any questions about conflicts or open meeting law? I don't actually have any more updates to share with you today.
One question.
Mhm.
Does declaring the conflict, does that mean that the person must recuse themselves and leave the building? Or
No,
on the dais?
yeah, I mean, I think it would probably be better to not be on the dais, so it's not even an appearance that you are participating.
Yeah,
But I don't think you have to leave the building.
Right. Generally, in the past, it's been customary that the uh, the elected or appointed official that declares a conflict would vacate the dais, sit in the audience. Sometimes they leave, but most often it's just fine to sit in the audience and wait for the case to be resolved, a motion second voted on, and then rejoin the dais at that time.
Okay, thank you.
And then of course, if you want to know where these statutes are and everything, you can let Luke know. We'll get you a copy of them. I mean, they're all online. 38502, I think, is the one that has all the definitions of 501, or 502 has all the definitions for what a remote interest is.
We had, I'm trying to think, generally because the community is so philanthropic and volunteer driven, we've had a case where the museum brought forward a special use permit, and one of the members on the planning commission at the time said, "Oh, I donate to the Cave Creek Museum." Am I, and that's not the, people that donate or volunteer or something like that, they're not getting a pecuniary interest. They're not receiving a benefit by that. Would you agree, Kristen, in those types of cases?
Yep, exactly. You have to satisfy both of those kind of prongs, that it's substantial and that there's that pecuniary or proprietary interest. Now there are many cases, more often than not, when someone asks, a public official asks me to help them analyze whether they do or don't have a conflict. More often than not, I haven't found that they fall under the conflict. It's just something that may appear to be a conflict, in which case you could still go through the you could declare, I don't want to give the appearance of a conflict, but then you can't just like jump back in and participate. You're done. If you say you have a conflict, you're out for that entire matter.
And don't use it as an excuse to avoid making
Conflict.
on a zoning matter that might be unpopular.
Yeah. Well, yeah. Well, because as soon as you declare that as a conflict, if and you don't actually have a conflict, the members of the public will just see it as a conflict. And so then when you do something, maybe in a similar matter, but don't recuse yourself, you may be called out on that. And that could present conflict at that point. Or I don't mean the type of conflict of interest. I just mean there could be a dispute with a member of the public and misunderstanding. And so it's really important to review them and declare it when it exists, but to not, be overly and start, not participating in the decisions.
Yeah, and as Kristen suggested, any cases or matters that are brought before the Planning Commission with a time that we allocate in advance of the meeting to publish the agenda and circulate it. If anything comes up where you have a question about a conflict of interest or potential conflict of interest, just reach out to myself. I'll put you in touch with Kristen or her partner, Bill Sims, and they can talk you through, whether or not that does rise to the level of a recusal for an upcoming case.
And remember, the decision will always be yours personally. So we can't tell you that you have a conflict of interest. You'll have to make that decision, but we can help advise on what, how the statutes and the different subsections may relate to each other and analyze the issue. Any other questions, concerns in general about open meeting law? I mean, you don't really have to worry about public records very much. Conflicts, nope.
It's like, it's a quick study and we're good.
All right. Well, if anything comes up during the year, just let Luke know and I will chime in if you need me.
Thank you, Kristen. We
Thank you.
appreciate, thank you for your time today.
All right. Thank you all. Have a good afternoon.
I am going to, one thing I didn't cover in my report that I wanted to disclose to you all, since the House Bill 2447, like I stated earlier, we are still being proactive as staff in reaching out and giving the public notification on pending projects, upcoming projects, projects under construction, that and the like. With that, our planner, Eric Baker, on our website has created an interactive web-based map that shows the map and location and progress of all pending applications and projects with issued permits under construction. So I'm going to quickly share my screen to show y'all what so here's the map. Like I said, it's available on the town's website. It's under the Development Services Planning and Zoning tab. There's several actually interactive maps that Eric has developed since being on staff. He just celebrated his 3-year anniversary this week, actually. It's amazing how time flies. But you can see here, you've got the Galloway Ridge or Galloway Crossing apartments that are under construction. They're all framed up. Likely getting another case for the commercial frontage there soon. The Mercado is not quite moving along. The Cave Creek Hotel and Spa, they're in for building permits right now. So there's some identifying characteristics about, when it was submitted, when it was reviewed. And then we'll continue to update those cases as they move through. So, and then it gives the staff contact. So if anybody, members of the public, has questions specific to that project, they know the direct staff member to contact and get any questions clarified. I know that's public involvement, public outreach is always a big deal, and that was evident when we were going through those ordinance revisions, removing site plan from, it's really site plan just boiled down to an opportunity to let neighbors know that a new commercial development was going in, and it met the requirements of the ordinance and the like. So, but this is just one more tool in our belt to make sure the public is notified and kept informed of different projects. So we've got quite a few around here. Carefree Highway, the zone change, Cave Creek Gateway. That was actually the last site plan that the Planning Commission heard. That was also a zone change case associated with that commission heard. So just one more thing to arm you guys with is, you're out checking your mail and your neighbor wants to know what the heck's going on at XYZ. You can, if you know the project, you can inform them, but you can also direct them to the website. And they can at least get in touch with a staff member and get their questions answered, or they can always call me. So
Let's just do the commercial stuff.
yeah. So, I mean, if we had a subdivision plat in process, that would be on there. Anything that's an applicant, a zoning entitlement type application. And then also, in the future, the Planning Commission would consider special use applications. And that kind of gets into what we're going to be talking about starting in March here about that section 3.5 of the zoning ordinance, making something special use. But those cases would appear as well. Anything planning related, Planning Commission related. We would, yeah, it's pretty easy to populate and to keep updated. So yeah, definitely it's a good tool. And I mean, the best thing, the other component of this is, this other interactive map here. It's got our land use zoning. This is really cool. So, I mean, you can just highlight the different features, bring up roads if you want to show street names. Cave Creek Wash, so it'll bring up floodplains. And this is all available on our website. You can do parcels, you can do the land use, turn off the zoning just to see what the land use is. It identifies subdivisions. So this was born out of, we've got subdivisions that are PUDs or PADs that have essentially each subdivision is a zoning ordinance unto itself. It's got adapted setbacks and lot coverages and disturbance development envelopes. So we get a lot of questions from realtors. Oh, they're looking at a lot in Red Dog Ranch. I see that the zoning is DR 190, just using as an example. Well, if you look on this map, it says, well, here's that subdivision, contact the planning department see this property, it's got a disclaimer, this property is within a subdivision as a result of zoning bulk regulations such as setbacks, lot coverage, blah, 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 may deviate from the zoning district. So it's got a lot of useful information. It's, very cool. Yeah.
I like how it has the overlay of land use, but then you can also
You can,
see the zoning, see the
Yep.
discrepancy.
Yep. So it's been a very helpful tool with property owners, realtors that just have the general questions. We can say, hey, I'll take you there in 3 clicks. You got your browser open, let's go.
Yeah.
So, and that really kind of concludes everything I have for the commission today.
Is there any, as far as this map, as far as any overlays for utilities and sewer and stuff like that?
We do have that in-house, and that's something that we've discussed in-house, making public. There's a lot of security reasons associated with why we wouldn't want to put detailed infrastructure drawings available publicly.
Well, no, I was just thinking like, let's say property owner wants to see where the sewer is because, the property they're looking at is not on sewer, but they have to worry about,
We get that a lot, and we just tell them, come on down, and we bring up our internal map and sit with them and go through that.
Okay.
Yeah. Yeah, definitely. That gives us an opportunity to kind of white glove the public as well. Show them all the utilities in and around there. Anything else from the commission today? It's great seeing you guys. Happy 2026.
Yeah.
As Kristen said, as far as legislation goes, 2025 was kind of a meh year, but we'll see what happens.
Do you think we're gonna have any rezoning applications this year?
We anticipate potentially a few more. I believe there's 3 more parcels along Carefree Highway on the north side within the Carefree Highway specific plan that may come forward. There's also been discussion by an owner within that district to maybe do a zoning text amendment. So we'll see. It's been kind of in discussion for a while. I don't know if that'll come to fruition this year or not. But yeah, we'll go over all of that in March. March will be a really good meeting, and looking forward to getting your feedback on some of the different ideas we have and direction from you guys on how to proceed on the matters at hand.
Sounds good. Yeah. If that's it, we can conclude.
Is there a motion to adjourn?
I'll make a motion to adjourn.
Second.
All in favor?
Aye.
Aye.
Thank you all.
Yeah, sorry I was late.